I'm going to talk a bit about arbitration, and it's going to be fairly general. And Rick, if you could give me a warning when I've got about 5 minutes left, I'd appreciate it. I'm going to follow the outline, but I'm going to ask you to go ahead and interject questions anytime you want, okay? I can't get through the entire program. The second page has some substantive issues, and I don't expect to go very deeply into those, okay? So when I'm speaking of arbitration, I'm thinking of labor arbitration. This would be arbitration between companies, employers, and unions. And as you know, unions are on the decline today. Probably the numbers vary, but about 12 or 13% of the workforce is unionized. In the private sector, it's closer to 8%. In the public sector, it's about a third, about 35%. Police, fire, many federal sector employees are unionized. But we've seen a very dramatic drop in unionization from about 1 out of 3 in the mid to late 50s to about 1 out of 10 today. How does a case get to arbitration? When I think of a case, I'm talking about a dispute, a disagreement between the parties. Remember that unions and employers have a written contract that they've agreed to. They've negotiated a contract, they have terms which bind them to a particular procedure. So if one side or the other believes there's been an abuse of that contract, they have the right to seek, try to get it fixed. Usually they do this through the grievance process. And the grievance process is a 3, 4, 5-step process. It's internal, generally starting at the lowest level between an individual and his supervisor, and then going higher. If the parties do not agree to a resolution, they have a right to go to arbitration. How does it get to arbitration? Well, most of the time the parties will seek an arbitrator through the American Arbitration Association or the Federal Mediation and Conciliation Service. FMCS is a federal agency. AAA is a private organization. There's a third way that people get selected, and that would be through something called a private panel or a direct appointment. And that's when the parties have some knowledge of an arbitrator and they mutually decide upon this person. If the parties go through a panel from FMCS, they usually get an odd number of names, like 3, 5, or 7, and they flip a coin to decide who gets the right to strike the first name. So if I'm the union and I win, I strike the person who I think would be most favorable to manage with. And of course, management would strike the arbitrator that they think would be most favorable to the union. And you can do this through doing a bit of research. So the arbitrator who remains is not selected because he's loved by the parties. He or she is least undesirable among the parties. But it's not a bad process, and it generally works. I often have trouble getting dates. I just recently was assigned a case in North Dakota, about 100 miles north and west of Fargo.
There's nothing up to that far.
There's a military base up there. So anyway, I tell my wife, I said, goodness gracious, this was in August. I said, I got to get this one real early, and I got to get these dates settled very quickly. So I sent them out a bunch of dates, and they wrote back and said, none of those work. And I sent them some more dates. They said, none of those work. I sent them 29 dates, and they couldn't pick a date that worked. And I got a little bit upset. And I emailed them, and I said, could we have a conference call and start over and see if we can't find a date? And we did so. I started in August, September, October, November, December. Folks, I'm going to North Dakota the second week of January.
Buddy.
Oh.
I don't know if I'll ever get home. But we do have difficulty getting dates, and it always surprises me that the parties have that much difficulty. The process itself is fairly simple. The first thing that you do is you try to figure out why you're there. And the parties often have agreed to a statement of the issue in advance. Statement of the issue might be something like this. Did the employer have just cause to terminate the grievance? If not, what is the appropriate remedy? Or it might be, did the employer violate the overtime policy when it administered it against Mrs. Smith? Now, the party that's taking the action has the burden of proof. So if the company terminates or discharges or disciplines the employee, the burden of proof is on the employer's shoulders to say why they had the right to do that. And that's called a discipline discharge case. The other kinds of cases are contractual interpretation cases. And those are cases where the union would say, the company didn't administer the pay policy properly. Well, the burden of proof is on the union's shoulders, therefore, to carry that burden. And the burden's a heavy burden because somebody's got to go first, and obviously somebody gets to speak last. And who speaks last has the last chance to rebut what was said. Point 2B is the exchange of exhibits, and this would be something like the contract, that would be a joint agreement, or an absentee policy, that would be a joint agreement. Anything the two parties agree to jointly to submit would be called a J1, J2, J3. Then you go to employer exhibits, union exhibits, and those are generally introduced through testimony by the witnesses. I've already spoken about 2C. 2D is the opening statement. What you probably don't understand is when I go to a case, I don't know much about the company or the union or what the issue is. They don't tell me in advance. They don't tell me why I'm there. So after I have an idea of what the opening statement, what the issue is, then the parties generally take 5 or 10 minutes to brief me what this is all about. And the opening statement, I think, is very important. Many parties will write it out and give it to me. Might be a 1 or 2 page statement. Gives me a nice overview because you've got to remember I'm a stranger coming into an environment where I'm a neutral. And if I have any connection with the company or the union, I have to disclose it in advance. I don't have the right to hear a case if I'm not in part. I'm revealing more and more as time goes on. Last 3 cases I've had to describe a relationship that I've had with an employer or a union. Typically, it's people I've worked with in voluntary settings, professional associations. But they have the right to know that, and I remember John Gilbert, who was a neighbor of Rick and mine. He's a labor attorney for an employer. He selected me to be an arbitrator, and we had sons, and our sons were rather close. And I was quite surprised that John picked me. But I immediately wrote both parties describing the relationship we had, and then finally saying, notwithstanding this relationship, I think I could be an impartial neutral. The union attorney picked up the phone and called me and said, John told me all about it, and I picked you anyway. So that was nice to know that John revealed our relationship before we started. And I certainly felt I had an obligation to reveal that. Okay, you have an opening statement that gives an overview, then you have testimony, and you take witnesses. There's a direct examination, cross-examination. They're sworn in, they are under oath. There's a cross a redirect, a recross, and I let that go until the parties are satisfied, until they're finished. I try not to ask too many questions. Each question I ask generally benefits one side or the other. So if it's something technical, if it's something about a process or procedure, I don't hesitate to ask questions about that. I remember one case I had that involved marijuana on a loading dock, and the parties kind of danced around what I thought was a fairly important issue. I wanted so much to ask a question, but I figured if they didn't want me to know about it, I guess I'll just take it the way it is. So I didn't ask that question. The parties have the obligation and the liability to make their case. It's not up to the arbitrator to make the case for the party. Now, that's particularly troublesome to me when you have a seasoned veteran attorney and a inexperienced advocate for the other side. And that advocate may not be an attorney. And you know, it seems like the table's tipped. But all I can do is help them through the process. I can't make their case for them. So I can tell them what we're going to do and how we're going to go about doing it. But I hesitate to ask a lot of questions. I try not to. I'm not always successful, I'll be honest with you. So we have our direct testimony, we have witnesses, we have cross-examinations, and then we go to closing statements. More and more I'm finding that employers and unions are preferring to write written briefs. And a written brief would be a 10 to 50 page statement that's sent to me after the hearing telling me why I should rule in their favor. And almost always I'll have transcripts of the proceedings. So we wait until the transcript comes in. The transcript might be 200 or 300 pages, and then the attorneys will write a brief based upon the evidence that was presented, as well as perhaps make reference to the transcript itself. Point 3 is 7 tests of just cause. Most of the cases that arbitrators hear have to do with discipline or discharge. And I think these are rather prudent rules or guidelines. You might find them useful in your own setting. If the answer to any of these questions is no, the company does not have the right to take action against the employee. So they didn't have just cause to take action. Let's go through them quickly. Did management give the employee forewarning or foreknowledge of the possible or probable disciplinary consequences of the employee's conduct? Well, did they tell him what was going to happen if he screwed up? If they didn't, then they don't have the right to take action, according to this set of rules. Was the rule or the order reasonably related to orderly, efficient, and safe operation? In other words, was the rule reasonable? In the view of the arbitrator, does the rule have applicability in this setting? C, did management make an effort to discover whether the employee did in fact violate or disobey the rule before it administered discipline? And then D is closely related to that. Was the investigation fair and objective? And at the investigation, did the judge obtain substantial evidence or proof that the employee was guilty as charged? Have the rules, orders, penalties been applied even-handedly without discrimination to all employees? That's one that arbitrators take pretty seriously. They look at past practice, and they look at what's been done in the past. And I'm not going to say that they're unwavering, but that influences me, particularly if the employer and the union have had a history of a practice in a particular manner. Now, the only problem I'm going to have is if that history of past practice is in direct violation of the clear meaning contained in the contract. Then I've got a problem. You know, I've got a dilemma there. Do I favor past practice, or do I favor the clear, strict wording in the contract? And lastly was the degree of discipline administered reasonably. Was it related to the seriousness of the employee's proven offense and record of the employee? I'll tell you a story about a case I had a long time ago, and it was a difficult case for me. I had a very large employer, and the employer had, I'd say 15,000 employees. The individual who brought the grievance forward had been selected last year as Outstanding Employee of the Year. He was an African American. He was an extraordinarily good employee. He had a spotless record. He was a truck driver, and the company had a clause in the contract which says employees must have control of their vehicles at all times. And if they don't, the employer has the right to take discipline against the employee following a thorough and complete investigation. Well, this employee turned the corner and lost control of his vehicle and passed out. He wrecked the vehicle, did damage to the vehicle, and did damage to a building. They sent him to Barnes, did a full body scan, tested for blood and alcohol and drugs. He came clean. He was 40 years old, had 3 kids. He's crying on the witness stand. He'd been out of work for almost a year before I got the case. He said, I just want my job back. It's never happened to me before. It's never happened to me since. I've tried to find out why it occurred. I can't find out. Company sent me through a series of tests. Doctors couldn't tell them what happened. I've been a good employee. I just want my job back. The employer looked at me in a very serious fashion and said, next time we put him back to work, next time he's driving down the road, he might pass out and run into you. We can't put that guy back to work. You're here to do one thing, and that is to interpret the contract and tell us if we violated the contract or not. Well, again, I'm on the horns of the dilemma. You've got a 20-year veteran with a spotless record and a contractual clause in the contract which says following a full and complete investigation, the employer has the right to terminate the employee if he loses control of the vehicle. It was clear to me that the employee lost control of his vehicle. It was also clear to me that the employer had made a full and complete investigation. I put the guy back to work. I put him back to work in a non-driving job. I said, you can't put him back on the road. You got 15,000 employees, surely you can find a place for him. I didn't give him any back pay. Typically, when you put a worker back to work, you give him back pay. He had lost a year's wages, you know. It was a pretty good job. That was a tough one for me. And I still toss and turn about it. You know, I don't feel comfortable with it. I saw both sides of that coin. And, you know, I also find it's interesting that when I relate stories like this to groups like you, I tend to relate stories that favor a decision for the union. And somebody came up to me after a presentation and said, do you ever rule for management? I said, yeah. He said, well, all your stories included decisions where you awarded for the union. And I stopped and thought about it, and I said, well, really, if management did what they should have done, there wouldn't be a story to tell. Yeah. So I share that with you because I think there's a little bit of truth to that. Okay, point 4, the transcript comes to the court recorder, the date of the briefs are due, the board's issued. So that's it. I'm out of the picture when I write the award. I worry about this thing until I drop it in the mail. When I drop it in the mail, I forget about it. How much time we have, Rick?
You got 10 minutes?
Okay, do you want questions?
Sure.
You look at the second page, and here are a few issues that often come to arbitration. Absenteeism, insubordination, substance abuse, sexual harassment, seniority. I have a few bullet items on each of those. be happy to stop and ask questions now, and if there are no questions, I'll continue to go through this list.
Do you ever do any follow-up, or do you ever find out after the fact how things worked out down the road? For instance, the truck driver, is he still there, happy, working, anything changed?
That's one of the few cases that I did here. I've heard hundreds of cases, and I guess I've heard from maybe 2 or 3, and I knew the management attorney, and I bumped into him at a conference, and he looked at me and smiled, and I looked at him, and he said, "I thought you made a good decision." I said, "Well, thank you, it wasn't an easy one." He said, "We think the guy fell asleep at the wheel, but we couldn't prove that, and we didn't bring it up." So they were okay with it, but I don't know how the guys work it out. Sometimes there's retaliation against the grievance when he comes back to work. It could be subtle, and but it can't be obvious. You know, if it's obvious, it's illegal. Yes, sir.
Often, obviously, everything's black or white in many cases. There's an old adage, don't let rules overrule common sense.
Yeah.
Your thoughts?
Oh, I like the adage. I'd like to think that I do follow it for the most part, but it's awfully hard for me to overlook clear, obvious language that the parties agreed to. And when the language is in the contract, the arbitrator is supposed to stay within the 4 corners of the contract. And when you go outside the 4 corners of the contract, you seem to get in trouble. Do I have the right to issue an award on things that are, well, you know, let me say it to you differently. I don't think an arbitrator should ever substitute his view of fairness for that of the company if the company had the right to take action. And it's for that reason that I had so much trouble ruling on that truck driver case. You know, the employer had the right to do what it did. And I infused my view of fairness for that of the company when the company had the right to do what it did. You know, I never finished my last point, I guess. The last point the reason I told that story had to do with G, you know, 3G, was the degree of discipline administered reasonably related to the seriousness of the offense. And that's where I hung my hat. I said, it's that guideline that I'm going to use to support my decision. The degree of discipline was too harsh in my judgment. And I said, you don't have the right. All the other rules they had met. They did everything. But I did substitute my view of justice for that of the company by imposing the fact that I thought the discipline was too harsh. And that's how I'm sorry I didn't make that connection earlier. Yes, sir.
What is a typical fee that an arbitrator would receive for his or her services, and who pays it?
Almost always it's split by the parties. I've had some where loser pays, and they're not very common. Fees range in the St. Louis metropolitan area from about $600 a day to about $2,400 a day. I would say that the average is probably $1,000, $1,200 a day. And for each day of arbitration, it's going to take most arbitrators a couple days to do research and write up the award. So if I do a typical arbitration case, I'm going to be billing for something around 3 days. So that gets you a pretty good feel.